for listing of a matter in the motion column tomorrow, my lord.
Why?
My lord, this pertains to the lotteries. It was being heard by His Lordship Justice Nair sitting with the Honorable Chief Justice in the previous round of litigation, my lord. Our representation was rejected.
Tomorrow's. We'll have it on Wednesday.
My lord, the learned
Yeah,
senior
tomorrow there'll be some problem. I'm telling you, there'll be some problem. Something is there.
Yes, my lord.
Most probably after the second half, no court.
My lord, I will pray for the date then before that bench, my lord.
Wednesday.
Wednesday.
No, most probably it's second half, after second half.
I have a prayer for listing of 2 new writ petitions next Monday.
Which
For the
petition?
Writ petitions. They were wrongly listed before the learned single bench. But now they are supposed to be listed
Monday.
next month. Public.
3 writ appeals, my lord, we have preferred a month's back. My lord, another writ appeal, my lord, arising out of the same judgment, my lord, the SEBI matter, my lord, Security and Exchange Bureau, is coming up on 22nd. So these 3 appeals also, my lord, may be allowed to be listed on that day. There is a delay condonation also, my lord, on 22nd.
Lordship, I recommend in item number 21 and 24, Lordship. Lordship, allow us 6 weeks time to file our affidavit, Lordship.
24, my lord, I am appearing. 24, that was the last chance given, my lord, on the last occasion.
Let it reach. Let it reach.
Next week.
Both matters, let it reach. After that, we'll pass all this.
I am. May I present, Lordship, item number 19, action for the day.
Item,
19, 19,
you are appearing on behalf of?
petitioner.
Petitioner.
Action kindly after 2 weeks,
You are appearing on behalf of
petitioner.
M. Datta.
The A Khatun, Lordship.
Okay, on request made by MS A. Khatun, learned counsel for the petitioner. When do you want? After 1 week, 2 weeks?
2 weeks.
After 2 weeks.
May please, your lordship, I beg to mention item number 31. My lord, with the consent of the other party, matter may be taken after 11 December, my lord.
11th of December.
Yes, my lord.
You are appearing for?
The petitioner,
Okay, your good name?
D. Rathi. I am appearing on behalf of Mr. Amit Goel.
On request made on behalf of Mr. A. Goel, learned counsel for the petitioner. Please. You want a date fix, no?
No date.
After 4 weeks.
Much obliged.
I think one of daily orders. This matter may kindly take after some time. Lordship.
Why?
This matter will argue my senior Mr. M. E. Mondal, Lordship.
Before.
No.
Is 20? Okay. Okay, writ appeal has already been heard and is pending judgment, isn't it?
Lordship, clearly I cannot say it, Lordship.
Where's your senior?
Unless in another court, Lordship.
Okay,
So for the time being, Lordship.
we'll adjourn it.
No, Lordship.
Okay, let him come. We'll see.
I'm obliged.
So,
This is that reserve for us.
Yes.
Yeah, Your Lordship. appeal. Yes.
My lord, lordship may kindly say if the order is page 100
No.
and a party portion of the order, lordships may kindly see page 103, bottom. Having heard the learned counsel for the appellants, and after taking into consideration the impugned judgment dated 2/2/24 passed by the learned single judge in WBC number so, as well as the materials placed on record, we make it clear that though the learned single judge had opined that there is no illegality in the notice dated 6/12/17, but had also made it clear that forest authorities can only exercise its jurisdiction in the RF and PRF lands and not in respect of the revenue lands, we hereby clarify that before taking any actions against the appellants or similarly situated persons pursuant to the notice dated 6/12/17, the forest authorities are required to ascertain that the lands occupied in the appellants or similarly situated persons falls within the RF or PRF lands, and after ascertaining the
How many are filed?
same, the forest authorities can take any action against any against only those persons who have illegally occupied RF or PRF lands. So this is the order, my lord. Now, lordships may kindly see page 14, para 11. And that the petitioner requested that order dated 24/9/2024, which just now I have read, passed in writ appeal number so and the order dated so passed in WBC number so. After that order of writ appeal, we also filed a writ petition, and that same order was upheld, which was passed by the appellate court. Have been duly communicated to the authorities on 26/9/24 for implementation of the said orders, but the authorities still today have not carried out the orders in presence of all stakeholders, nor provided the gazette notification issued declaring that the revenue village RCDB has been included in the.
No course of action. What happened after the writ appeal judgment?
After the appeal judgment that was communicated, my lord,
Then
after communication, it was required to make a joint exercise between revenue authorities, forest authorities, and the stakeholders. But they have not done that, they are threatening that we will evict you.
you were aggrieved earlier by the notices that were issued to you for eviction.
Yes,
You approached the writ court.
yes.
How many of you approached the writ court?
And I read to a writ court, but you are not satisfied with the order of the land.
No. How many of you approached the writ court? How many petitioners?
That there, writ court, there is 535.
And after that, how many of you filed the appeal?
Appeal was filed 18 persons.
18 or 55?
No, appeal is 18. 18.
Oh, yeah,
Appeal is-
contempt is filed by.
Yes.
Then
Now,
that is one.
yes.
The second thing is you're not happy with the order passed by the writ court.
No, we are happy. We are happy, but that order is communicated. The forest office is required to make a joint exercise.
So you filed a writ appeal.
Yes.
Writ appeal clarified the
Yeah, matter, yes. That all this.
after that, what happened?
After that, well, they are not doing till today, rather threatening that we will evict you at any time. That lordship may kindly see page 19.
Any steps taken after the order passed by this by the division bench?
No, exceptions we have communicated the order.
You have communicated, that's fine.
Yes, but
Then-
they have not passed any order, nor exercised that power which the honorable court said them. They did not do anything, rather threatening. They are threatening
That lordship, we are saying that if the lands falls within the forest area or PRF, then there must be gazette notification, they are not providing that. So our case is that as should be the revenue village, that is not at all connected with.
See, in all possibilities, they are taking steps as per the direction given by the division bench.
Yes,
So till now, nothing has happened.
yes.
Then
No, well, they are threatening us. They are threatening us.
where?
And that was the view, my Lord Justice Nair was that if anything is happened or they do not, my Lord, the order of the court should be carried out both letter and spirit. Now, what they have done, Lordship may kindly see, page 19, kindly see for a moment. Page 19, para 17. That the petitioner of extradition that the contemners willfully intention and in a desperate manner showing total disrespect to the Honorable High Court, High Court have violated the order dated 2
Yeah.
24% W and also the order dated so and so.
Mr. Mahmood, you had approached the report by way of a petition saying that the excelling the eviction order.
Yes,
Then the report passed certain directions.
yes.
That was carried upon appeal in this order, page 100.
Yes.
Right? This court said that if the state authorities are proceeding to evict you,
Yes,
they will do so only after ascertaining whether the land is falling under revenue
yes.
or a forest land.
Forest land.
Now you have not made any statement that without ascertainment, they are evicting you. They have not ascertained, that is one thing.
No, madam.
And para 11 is totally on a different context. That is not in terms of the orders passed by this court.
No, my Lord, kindly see then page 15, madam. It is a long drafted matter.
We are reading from the.
Page 50, it is from page 14 bottom, para 11. The petitioner requested that order dated 24/9/24, passed in WB of so-and-so and order dated so-and-so, passed in WB of so-and-so have been duly communicated to the authorities on 26/9/24 for implementation of the said orders. But the authorities till today have not carried out the orders in presence of all stakeholders, nor provided the gazette notification.
Where is that direction? That you have to be provided with a gazette notification.
No, my Lord, because our
Only direction of this court is that you will not be evicted without carrying out that assessment. You have not been evicted.
no, my Lord, my submission is this. Let me clarify.
Contempt proceeding, Mr. Mohan.
And let me satisfy your lordships. One thing is this, but how the land is forest land or revenue land, that shall prove by the gazette notification.
Where is that direction?
No, that direction, it is included.
We'll
It
not
is
read
included
into the-
indirectly.
We'll not read anything indirectly. We'll go by the plain terms of the order.
Well, it is forest land or not a forest land, how we can understand?
That-
Last, just read the last 3 lines of the order, page 103.
Yes. Yes, 100,
103.
103, yes. Yes, last 3 lines, madam.
Before-
We hereby clarify that before taking any actions against the appearance or similarly situated persons pursuant to the notice dated so and so, the forest authorities are required to ascertain that the lands so occupied by the appellants or similarly situated persons falls within the RF, reserve forest or proposed reserve forest lands, and after ascertaining the same, the forest authorities can take any action. So it is
Against,
within the order.
against,
Against only those persons who have illegally occupied the RF or PRF lands.
after this, what happened? Anything
Now,
happened?
my lord, to ascertain that whether forest land or proposed forest land, that is, now how it can be proved, my lord? Only by document. My
I
lord,
think- I've taken notes there. There's nothing.
if the authorities are genuine, my lord, let me satisfy your lordship. If the authorities are genuine that this is forest land, where is the,
Mahmood, there's no contempt. There's no contempt.
my lord, may I pray that lordship may fix the matter another day. Let me say what is the contempt, whether the contempt is direct violation or with letter and spirit. So
We see no contempt here.
on the, no, that lordship is correct for that today. Whether I can satisfy your lordship.
Today we are.
The other day I can satisfy.
Tomorrow also we will be correct, day after also.
No, my lord,
correct.
the other day I will satisfy your lordship, though there is contempt because indirectly. So let the matter come after 2 days. That will satisfy better manner.
Request made by Mr. M. U. Mahmood, learned counsel for the petitioner, at least after 1 week.
All right.
3,
What is this?
3,
Lordship, before starting your lordship, in this case, I am preparing for respondent number 1. I want to file my affidavit, your lordship. Although affidavit is ready, but due to illness of Mr. A.R. here, I could not file it here. So I am seeking only 1 week's time, your lordship. Let me allow only. Earlier also, your lordship, please to grant time, madam. But only thing is this, madam. My salary up to October, 2,70,000 is not paid. So, my lord, it is a question to be decided by the government. And the appeal is admitted.
What is the order under operation now?
My lord,
Status quo order, isn't it?
my lord, status quo.
As per the status quo, what is the position?
Status quo means, my lord, I am working. Working will continue.
Lordship will have a look at page 183. That will clarify the entire position. Page 183. Paragraph 15 of the first writ petition. Says the effect of provincialization will not be there. It will not be there.
The first writ petition, your provincialization was kept in abeyance.
Right.
Matter went to the DSC.
Right.
Director. Director passed an order on 10th of February. That should again put to challenge.
Right.
This court interfered with that order, with the further direction that the status quo order, the directions passed in the first writ petition will continue. Right? You are not on job. Your
I am on job.
Your provincialization was directed to be kept in abeyance and continue. Matter was remanded back to the director
My lord.
for fresh consideration.
My lord.
You filed this appeal.
My
A
lord.
status quo order is passed.
My lord.
The only effect is the director will not consider. But where is your provincialization effect? Provincialization revived. Not revived. So
Well,
you
look,
will have to hear the writ petition, writ appeal before going into it. That's how you will have to get the writ appeal.
My lord.
Consider that. The
Then, my lord, retable may be fixed.
You will, you.
Retable is already admitted, my lord. So, my lord, my salary question is involved. In that case, my lord, a date may be fixed for hearing of the.
That's fine. We'll fix a date for hearing of the writ appeal.
Yes, ma'am.
But this IS, you can withdraw it.
My lord.
There's no point keeping
Yes,
it.
ma'am.
Mr. M.A. Sheikh, learned counsel for the applicant. Place for withdrawal of this IA. Do you have any liberty? No, no liberty. Mr. R. Majumdar, learned standing counsel.
Education
Appears for the secondary education, elementary education department. Stop. I was dismissed on withdrawal. Para. Okay, yeah. Okay, I'll request made by M.A. Sheikh, counsel for the appellant in the writ appeal. When do you want?
My lord, in December, my lord,
In the month.
some date may be given.
Give a date convenient to
My
you.
lord. First week, my lord.
Fifth? Oh, no.
Fifth. Okay, my lord.
We'll have it on 10th. 10
10th.
days.
All right.
Appellate.
Four.
How many of you?
We are about.
Seven.
One, two, three, four, 5, 6, 7, 8, 9, 1 to 14 applicants.
Thanks for the applicant's name. Fourteen applicants.
Yes,
Yes.
I just to tell your lordship, when this rule was framed before I was an AG. And that's why I have to say to your lordship, but thereafter, I think there will be no clash of interest in this case. If there is a clash, I find there is a clash of interest, I'll come out from this case. So this rule was framed, then the government. So I became an AG and this rule, there at one point of time, the lawyer, I think JC, had challenged the rule. They said that how this rule, because in the schedule, chief in engineer in chief, and they have promotion scope is there, but there is no promotion from civil wing. Their whole case is that in the rule it is not been mentioned, but in the schedule it has been mentioned. That's the case. But I think we should be heard in this case. If they want to file any objection.
Notice, oh, it's coming up for first time.
Yes, yes, of
So
course.
notice has not gone. Anybody
Yes.
appearing for petitioners in the? You have,
But I think the notice should go to the petitioner
okay,
also.
heard Mr. D. Das, London Senior Counsel, assisted by Ms. S. Sharma, London Counsel for the applicants. So, issue notice. The applicants, no. You are appearing for
Response number 16, 17 and 18 in this file.
16?
17 and 18.
About 18 and 19. Okay, Mr. You're good. A. Barwal, Leonard,
CA major.
Governor Advocate Assam, Mizoram. Appears on behalf of the opposite parties 16, 17 and 18. Stop. Para applicants to take steps for service of notice on the opposite parties 1 to 15 and 19 and 20
Yes,
by registered post,
yes,
registered post 80 within 1 week.
yes, will do.
List after 4 weeks.
Deeply applied.
5.
Yes. How many days?
82 days.
Only contention financial hardship. Para 3.
You have any objection?
Let it be, my lord. Condone it only in the prayer portion. I have objected it verbally. That may be recorded.
Then we'll continue it. But Mr. L.R. Majumdar, then the counsel for the applicant. So by this application, the applicants are praying for continuation of 82 days.
83 days.
83 or 82?
82.
82
In the
days
prayer portion, it is 83.
in preferring the connected with applicant. Stop. Para. Mr.
And Dusman.
And thus, Leonard,
Government advocate.
Government Advocate submits that no proper application has been given in the present application, and accordingly, the prayer for condonation should be rejected. So, but we have considered the cause shown in the present application, and we are satisfied with the explanation given at para 3 of the present application. Stop. Accordingly, the prayer for condonation is allowed. Highest disposed. Registry is directed to number the writ appeal and list the matter in its usual course.
Appellate. 6. Yes. Lordship may not take up this.
Some other bench list its matter before any other bench without one of us. Within bracket, you justice, you can.
Appellate. 7.
Lordship, this appeal is relating to a common judgment. In the other cases, it was admitted already and also fixed for final disposal on 22nd. But there was some connecting cases where we could not file the appeal on time. So there is a delay of 123 days. So Lordship may be pleased to issue notice and also allow us to take justice service.
But Mr. D. Saike, you are appearing as
As a senior counsel for SEBI.
the senior counsel assisted by Mr.
B. Gogoi.
Learned counsel for the applicant. Issue notice. The applicants to take steps for service of notice on the sole respondent.
Sole
On the
respondent.
sole respondent by registered proceeding within 1 week.
Lordship.
Within 1 week, along with Dusty, my lord, in similar cases, that order has been passed.
Okay, within 1 week. Para.
Returnable may be given Lordship 22nd.
Additionally, applicants are also allowed to take steps for service of notice on the sole respondent by justice service to the register of this court within a period of 1 week.
If it is fixed on 22nd, Lordship, within 3 days.
Within 2 days. After applicant shall file an affidavit to the defendant. Is it a fixed matter?
Yes,
Yeah.
Lordship, it is a
When
fixed
is it?
matter.
22nd.
22nd. In fact, the matter was about to be heard, then Lordship, the division bench one decided that other cases may also be filed.
There was no point in issuing the register. She registered for the wait.
In all, probably the single counsel is that he will accept it.
Okay, list on 22nd.
22nd. Lordship. Highly obliged. Lordship.
8.
May please, your lordship. 15 days delay, my lord.
Why 15 days?
My lord, file was dislocated in my chamber, my lord. So it is my fault.
Prayer process 17 days delay, man. In the prayer.
What is that?
17 days delay.
I think it's 15 days.
15 days, madam.
Any objection? Okay, heard Mr. Abhishek, learned counsel for the applicant. By this application, the applicant is praying for continuation of 15 days delay in filing the connected topic. Stop. We have also heard Mr.
And the
And thus,
2, 3, 4, 5.
government advocate for the respondents.
2, 3, 4, 5.
No. For the opposite.
And for respondent number 1, your lordship.
Okay, MS
And Bordelais.
and Borderland, Leonard.
Standing counsel.
Standing counsel, land revenue appears for respondent one. We have also heard, We have also heard MS so and so for respondent 1 and Mr. So and so for the responders.
2, 3, 4, 5.
Stop. We have satisfied with the cost shown in the present application. And accordingly, a delay of 15 days is my lord. Register is directed to register with appeal and list the matter.
Well, may I pray that a date may be fixed, my lord, or 22nd?
They will have to register the matter and then they'll list it, so you can make your mention of if it does not come up.
Oblige, lordship.
9. Admission.
May it please, your lordship. Well, here, my lord, the respondent number in favor of respondent number.
Yes.
When the area of operation was not demarcated, and now they have gone 1 kilometer ahead, my lord, upstream, my lord. And my lord, an inquiry is required, my lord, because my lord, in that part, my lord, because
Did you
of
make any representation?
my lord,
Did you make any
representation. Yes, I have filed, my lord.
where?
My lord, your lordship will find that page, my lord. 38, my lord.
This is nothing. Yeah.
How far is from here from Gondoli?
That's
47 kilometers. Why was this representation posted at here and not at near post office at Gondoli?
that,
What are the steps you have taken?
my lord.
Have you filed any criminal case?
No, my lord, no, my lord, no, my lord. But to be honest, my lord, the so far, my lord, this application is concerned, my lord, the presentation, my lord, it is not clearly stated, not clear, my lord. I do agree, my lord, on that part, my lord. But in fact, my lord, they are excavating the sand and the stone, my lord, 1 kilometer upstream, my lord.
Why not you file a proper application? Yeah, explaining all the steps that you have taken and the interest that you have. You withdraw the
Yes, my lord, then in that case.
Mr. N.J. Datta, Learned Counsel for the petitioner, appraised for withdrawal of this PIL with liberty to file application.
My lord,
Prayer is allowed. PIL is dismissed on withdrawal with liberty as per.
my lord, I'm obliged. Yes.
May please your lordships. My lord, this PL relates to mismanagement of my lord very revered my lord religious institution called my lord Haigrave Madhava in my lord Hazo. Hazo is a my lord place of pilgrimage for the Hindus, for the Buddhists, and also for the my lord Muslims. And my lord, this relates to the Haigrave Madhava temple. What happened, my lord? The issue is very small here. In 1908, there was a decree in a suit where, my lord, a scheme was my lord placed under which the my lord the activities of the temple will be run. Now, in 1959, an act came, and under that act, my lord, called the Assam State Acquisition of Lands Belonging to Religious and Charitable Institutions of Public Nature Act 1959, my lord, the under section 25A, how it has to be managed, my lord, that has been specified. Now, in spite of the, my lord, there having been a law, the temple is even now run under the, my lord, scheme prepared under the decree, which is in contradiction to the, my lord, act. As a result, my lord, there has been mismanagement in the sense that my lord, the suit was filed in 1908, the decree, my lord, was filed by a Doloe, and even now, my lord, he is the only person, my lord, who runs it without there being any transparency. Whereas, my lord, under the 1959 Act, my lord, there is a clear-cut direction as to how, my lord, it has to be run. Now, the difficulty is, my lord, there were two PILs earlier, and the matter was remanded back to the district judge to pass appropriate orders. But every time, my lord, the district judge is relying on the decree, my lord, he is, my lord, not following the act. That is the, my lord, issue here. The order that by which we have been agreed presently is, my lord, as page 132 annexure 14 and 138, two orders.
We can issue notice here.
Is my lord, this is only issue notice.
But Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. P.P. Datta, learned counsel for the petitioner. Issue notice. Revenue. MS and Bodole, learned standing counsel revenue. Department appears for respondent 1.
I am for 3 and 4.
3 and 4 and Mr. Sharma. DK. Learned additional senior counsel.
My lord.
Appears for respondents 3 and 4.
Sure.
How about 2?
My lord, I think standing counsel.
District Commissioner, no?
District and Sessions Judge, not a party, not a rating.
My lord, in fact, district and Sessions Judge is one of the, my lord, the members of the team which is running it, my lord.
Mr. H.K. Das, learned standing counsel, Guwahati High Court, appears for the respondent. Petitioner to take steps for service of notice on the respondents 5 and 6.
Five and
Registered proceeding with the one.
My lord, there is an interim prayer. I pray for an observation that on the returnable
Prayer
date,
for
my lord,
interim
the prayer will be
considered
considered.
on the next returnable.
I love this.
11.
May it please your lordships. Hello, this is relating to delimitation of Dilapur constituencies in Korimundra district. Some anomalies, as I have mentioned in paragraph 10, my lord, and 12, at page 9 and 12. The uniformity of population have not been maintained. So my prayer is at this stage is only issue a notice as well.
Well, deliberation process is over complete.
The notification is
The election notification is yet to be issued. The lordship may be pleased to issue notice on the point of maintainability.
Okay,
And
hurt Mr.
NH Majarwe.
NH Malawian and a constitution. Issue notice. You appearing on behalf of all the respondents?
Yes, lordship, all the respondents I am appearing. But my only submission is that notice may be issued only on the point of maintenance of this
Okay, issue
PIL.
notice on the issue of consent. Mr. D. Cycle, Advocate General, assisted by Mr.
Standing counsel, PNR.
K. Conwell, Learned Standing Counsel, PNR.
Yes.
PNRD department. Appears on behalf of all the respondents. When do you want
3 weeks,
this the matter after 3 weeks?
deeply obliged.
12.
May. May I please, your lordship? This is an appeal preferred against the order dated order in page number 84, passed by the learned single judge, lordship. Order dated 7/3/24, lordship. Passed by the learned single judge, lordship. Lordship, what happened, lordship? In this is the second batch of writ petition against which we have preferred the appeal, lordship. In the first writ petition, lordship, if your lordship turns to page 73, the respondent had preferred the first writ petition, which is the order which is at page 73, lordship. In that order, lordship, the relevant para is para 7 to 9, that is page 75, 76, lordship. In view, page 75 and 76, lordship. Paragraph 7 to 9, lordship.
Yes.
Earlier respondent has preferred this case, lordship. In this case, lordship, may I read, lordship? In view of the above, the matter is remanded back to the state level
Scrutiny Committee for giving adequate opportunity of hearing to the petitioner. Firstly, to establish that the aforesaid two persons, namely so-and-so, are respectively the grandfather and grandmother of the petitioner. And secondly, that the aforesaid two persons, namely so-and-so, being the grandfather of the petitioner of and so-and-so being the grandmother of the petitioner, had worked as tea garden laborers in the Bipinbak tea state, if necessary, by calling the records of the so-and-so tea state, so that the correct factual determination on the aspect can be made. Accordingly, the petitioner to appear before the state level scrutiny committee on 16/10/23 in the chamber of the joint secretary cum member secretary of the state level caste scrutiny committee under the social justice and empowerment department of the government of Assam, situated at D block first floor Janta Bhavan at 10:30 a.m. as agreed by both the Learned Council for the social justice empowerment department of government of Assam as well as the Learned Council for the medical education department of government of Assam. The legal right of the petitioner to claim a seat in the first year MBBS course in the category of TGL/X-TGL would be subject to the decision that the committee may render as per the provisions of the law applicable for the purpose. Accordingly, writ petition is disposed of. Lordship, after this order, Lordship, some of the petitioners being agreed by the order passed by the learned single judge. This is not a single writ petition. Several writ petitioners have approached the single judge, Lordship. Accordingly, some of the writ petitioners who are being agreed by this order, Lordship, has approached the division bench of this Honorable High Court, Lordship, and the division bench order is annexed 10, page 77. The relevant portion is at page 81, Lordship. May I read, Lordship? Page 81, Lordship. Thus, we are convinced by the submission of the Learned Council for the appellants that the direction given by the learned single judge in the impugned orders that the verification process shall be undertaken within a short period of 7 days, and that it would essentially involve collecting evidence of tea garden manager concern is in gross disregard and ignorance to the guidelines laid down in Kumari Madhuri Patil. The criterion of testing the validity of the certificates have been laid down by the Honorable Supreme Court in the case of Kumari Madhuri Patil. The same has to be adhered to in letter and spirit. The judgment in the case of Kumari Madhuri Patil clearly provides that the inquiry has to be conducted within a period not exceeding 2 months, and the result has to be communicated within 1 month from the date of conclusion of the proceedings, meaning thereby that a window of about 3 months has to be provided for conducting such inquiry. In the case at hand, the learned single judge, without any justification, directed hastening the process and curtailed it to mere 7 days in order to meet the deadline of 30th September. Then after that, Lordship, after few lines, after 3 lines, Lordship, down below, by directing an inquiry in such haste, the candidates already admitted might have been deprived of proper opportunity to place relevant material on record, and as a consequence, the truncated inquiry report resulted in the loss of 9 candidates who have already been admitted into the MBBS course. This is the judgment which the learned division bench has passed, Lordship. In this judgment, Lordship, the learned single judge was one of the judges who was there in that judgment, Lordship. After that, Lordship, after passing of that judgment, Lordship, in 7/3/24, the learned single judge has passed the order, Lordship, which is page 92 to 93, paragraph 21 to 24, Lordship. May I read, Lordship? Accordingly, in view of the proposition laid down by the Honorable Supreme Court by way of restitutional remedy, the respondent authorities are directed to grant admission to the petitioner in the next academic year, that is 24 to 25, by increasing the number of seats in the Assam Medical College, Dibrugarh. It is further provided that the admission fee deposited by the petitioner at the time of admission, by dated 7/9/23, be adjusted in the next admission. Regard being had to the claim of compensation after anxious consideration, this court is of the considered view that the petitioner is entitled to be compensated, as the petitioner has lost 1 full year for no fault on his part. This court, by order dated 12/10/23 in WPC 5941/2023, directed the petitioner to appear before the state level scrutiny committee on 16/10/23 at 10:30 a.m. on the consent of the parties, and the petitioner appeared with all documents. The state level scrutiny committee held its meeting on 29/12/23 and 30/12/23.
after a lapse of 2.5 months and found the caste certificate of the petitioner genuine and communicated its decision on 9/1/24. Had the decision been taken on 16/10/23 as directed by this court, the admission of the petitioner could have been saved. In view of the above, this court deemed it appropriate to grant compensation to the petitioner for the loss of one PCSA of first year MBBS course for no fault on his part. Accordingly, state respondents are directed to pay an amount of rupees 1 lakh only to the petitioner as compensation within 6 weeks from the date of receipt of certified copy of this order. Lordship, here we are not agreed with the direction passed by the learned single judge regarding the admission of the petitioner in the next year, that is in this current year. And accordingly, the petitioner, as per my information, the petitioner is means the respondent is already being admitted. The only part is that amount of compensation, Lordship. This part may be stayed, Lordship.
Why?
Lordship, because the division bench has clearly stated, and in the Madhuri Patil judgment also, the 3 months outer limit is there, Lordship. Where the learned single judge was also one of the judges in that judgment, Lordship, where the division bench has clearly stated that 3 months is the outer limit. But in the judgment, in the single judge, means in that order, Lordship, the learned single judge has stated that on the same day that has to be implemented, Lordship. That cannot be it, Lordship.
Yes, go good.
Otherwise, my lord, he has been admitted.
Ah.
And
Yes.
against the compensation part, my lord, the health department has also preferred an appeal. Only on that point, my lord. Kumari, Madhuri Patil.
You have also filed an appeal?
Yes, my lord. It will be listed shortly. We have given him admission. We are not against the admission part.
Yes,
But
Lordship.
regarding compensation part, my lord, it will take time. My lord, Lordship has already dealt with, my lord, by sitting in the single bench. At least minimum 3 months time is required, my lord, to have a fair inquiry. And in fact, that has been observed by the division bench, my lord, while in the last year, my lord, lots of anomalies happened, my lord, in this regard. Haphazardly, it was, my lord, conducted. Subsequently, it was founded, my lord, they are otherwise eligible. So they have now been inducted. And in the present case also, my lord, after thorough inquiry, he has been found to be eligible. That's why he got the benefit and he has been admitted, my lord. But, my lord, to hold it, my lord, within 1 day or within a week, this is difficult, my lord.
Our prayer is very limited, Lordship. The compensation part may be stayed. Otherwise, we don't have any grievance against the respondent, Lordship.
Heard, Mr.
Correct.
That's Standing counsel,
Lordship.
which department?
This is Social Justice and Empowerment Department.
Social
Lordship.
Justice and Empowerment Department for the appellants.
Lordship.
Stop. We'll have to issue notice then.
Lordship. Lordship.
Issue notice. The appellant to take steps for service, Mr. B. Gogoi, Leonard, Standing Counsel, Health Department.
Well, 2 and 3.
Affairs for respondents, 2 and 3. And how about 4? 4 and 5?
4 and 5, government. Director of the
4 and 5, Plain Tribes Welfare.
and district commission.
Preferred by government. Lordship.
Government.
Government.
Yes, I forgot this. You're not the appellant.
Lordship, this is a department under social justice, welfare of plain tribes and backward caste department, as well as state level caste scrutiny committee. These all departments are under social justice. Parent department is social justice department.
Social justice.
Lordship.
Okay. And Mr. N. Das, then government advocate, appears for the respondents, 4 and 5. The appellant takes steps for service of notice on respondent 1 by registered post ID.
Lordship.
List after 4 weeks.
Stay in the-
In the interim, in the interim, para 23, isn't it?
Lordship.
Para 23 of the judgment and order dated 7/3/2024, passed in WBC 7103 of 2023, shall remain suspended in the next.
My lord will add 1 line, my lord, in the order, because moment he gets the notice, the respondent number 1 may panic, my lord. Or should we clarify that this appeal is only against the compensation, not against his admission?
Yes, Lord.
That may be clarified. He is a student, my lord, he
uh,
must not panic.
Mr. On top, heard Mr. Iram, just understand, sir. It is submitted by the learned standing counsel that the appeal is filed that the appeal against the judgment order dated 7/3/2024, passed in 7103/2023, passed in WBCR 7103 is filed only against the compensation amount granted by the single judge. And they have no grievance with regard to the admission of the respondent of liquid petitioner for the in the MBBS course for the session 2024-20.
Kind of list.
13.
May I please, your lordship. Lordship, already bank guarantees and case. So lordship issue notice, admit lordship. In fact, these banks CRD method earlier. This same very bench.
Is it?
Yes. Lordship, against the interim order, they came before this court and this bench was rejected and this bench sent back.
Okay, heard Mr. A. Sharma, Learned Senior Counsel, assisted by Mr.
A Gautam.
A. Gautam, Learned Counsel for the
Petition.
appellants.
Yes, lordship, appellate.
You appellant?
That's one number 1 to 4, my lord.
How about 5?
I think notice through register has to go, man.
Yes, lordship, we'll take steps.
Okay,
PN Goswami, additional AG for 1 to 4.
notice, Mr. B. N. Goswami, Learned Additional Assam, appears for the respondents.
1 to 4, my lord.
1 to 4. Appellant to take steps for service of notice on respondent number 5 by registered proceeding within 1 week. List up to 4
Only
weeks.
one liberty lordship, pendency of this appeal will not be a bar for compromise lordship. Some talk is going on lordship.
They have already
Sometime-
preferred an appeal before the
So I know.
Delimitation Regulatory Commission that has been rejected on merit.
Pendency is not a bar lordship. During the pendency lordship, whatever.
That may not be there, my lord.
It was filed on 2020.
I know. Talk is going
In the
on. that
meantime, my
way.
lord, in the meantime, they prefer an application.
So
before the Regulatory
what
Commission.
do you want not disturb? Pendency of this writ appeal shall not be a bar on the part of the parties
Parties to talk and
to come to a compromise.
yes.
Come to. Okay.
14.
But this appeal is against a common judgment. But we have preferred 5 appeals. But I pray for taking up the matter on Friday, along with the other appeals.
This one.
This one, we have
Okay, okay, on request made by Mr. D. Nath, Learned Senior Government Advocate. Appealing for the appellants, list down,
Friday.
22nd.
27. Not
15.
No, in this issue, my lord, there is some other cases still pending before this honorable court, my lord. Always notice is issued, my lord. And this several cases, my lord. There's only a single copy, my lord, this passed, my lordship. This really
You
depends,
know you are appearing before a division bench.
my lord. Yes, my lord, sorry, my lord, because today I have some incident morning, my lord. So I have personal problem. My junior is not prepared.
You had 3 days holidays.
Yes,
3
my lord.
days.
Sorry.
Okay, heard Mr. SK Medi,
Yes.
CGC
Yes, ma'am.
for the appellants. Issue notice. How many respondents petitioner to take steps for service of notice? All the same respondent by registered for city within 1 week from today. Stop. List of the 4 weeks. In the interim, the order dated
My lord,
4/4/2024.
4/4/2024.
passed in OA number
3 of 23.
5 of 2023 shall remain suspended till the next.
My lord, other cases, my lord, there's WPC 256, 2024, 258, 2024, 8 and 39, 2024, on 1973, 2024 spending, madam.
Oh,
Yes, maybe come along with them.
Let it come up on its own because we are issuing notice.
Yes.
After the return,
The other cases also is notice.
Okay. Yes.
16.
Same
Also,
order.
similar.
What is the order?
Well, the order is at page malot 21 malot, and it's A
21.
mal.
Okay, heard Mr. You can go Swami, learn a CGC for the appellants. Issue notice. Appellant to take steps for service of notice on the sole respondent by registered post 80 within 1 week from the start. List up to 4 weeks in the entry. The order dated 15/3
Mal.
2023 passed in OA number 59 of 2019 shall remain suspended.
17.
My please, Your Lordship. So in this kind of award was passed, award was passed, and that award was upheld by us. Now award becomes, oh, sorry.
We listed on 22nd, similar matters, I'm told similar matters are listed. Okay, on request made by Mr. A. Dustal, Senior Counsel for the Appellant, list on 22nd.
Yeah, this matters, my lords, the petitioner taken loan, my lord, from the bank, my lord. From the bank. My lord, the loan amount was 2,31,000, my lord, 2 crore 31 lakhs, my lord. And it becomes, my lord, 2 crore 64 lakhs, my lord, something. But after sale proceeds, my lord, they collected 4 crores, my lord. And entire amount they have only 9 lakh rupees, my lord, returned without any due procedural law, my lord. The excess amount of interest, my lord, without any procedure. Actual ledger amount 2 crore 64 lakhs, my lord. They demanded also 2 crore 64 lakhs, my lord. 2 crore 64 lakhs, my lord. Without any due procedural law, my lord.
You have an alternative for?
My lord, because I had not come against the, my lord, the procedure, my lord, because 2 crore 64 lakhs, my lord, but the excess, my lord, thereupon for the excess amount, my lord, because of the, I am not agree with the sale procedure, my lord. There is alternative plan, my lord, but 2 crore 64 lakhs, my lord, actual amount, but they have taken 4 crores, my lord. That is why the 1 crore 7 lakh in the nature of, my lord, excess amount, 1 year 8 months, my lord, they have taken 1 crore 70 lakhs, my lord. That is why the procedure is otherwise of the surface X, my lord.
Page 129, the third class para.
My lord. $59, my lord.
129.
129.
I think many cases has been dismissed.
Moreover, my lord. Moreover, after going to the record, it is evident that the auction sale was completed on 19/4/2023. But the applicant, my lord, this is relating to the movable property. I am not agree with that. Movable property, my lord, 9 lakh collected. For the entire amount limitation, my lord. I have no agree with the movable property. They can take my movable property, my lord. Car, share, etc., my lord, of my hotel. But the entire amount, my lord, this is for the limitation, my lord, that amount, my lord, for that amount.
I don't think we can entertain this.
This is movable property, my lord, 45 days. Yes, that my Excel process completed, my lord. I have not come against that, my lord.
We cannot entertain.
But it's total injustice, my lord.
No, we are finding it difficult to entertain your writ petition. You've approached the alternative.
These are ledger amount 2 crore 64 lakhs, my lord. And 1 year.
Supreme Court is very clear on this. Supreme Court is very clear on this issue.
Yes, my lord.
They have
The
issued
Supreme Court
repeated orders.
But in some
and,
time,
this-
exceptional cases, lordships may entertain this petition.
Despite
my lord.
all these
But
orders,
the notice may go.
I'm
my-
sorry, we cannot entertain this writ petition. Either you withdraw and approach the alternate appropriate forum, or we dismiss it. It's up to you.
Whether dismiss, my lord.
You want to dismiss?
Yes, my lord.
We'll dismiss. Okay, dismiss.
My lord.
You write the adjustment.
No,
33 of supplementary list.
Oh, this. Oh, just appear.
Because this is a fresh matter and the PIF. We are challenging the wires of the amended Forest Conservation Act. If the lordship will kindly look at the.
One additional affidavit. This is the only one I could read. Yes. He could not find it. Issue not. Yes, who appears for the union? One and two. Can you at least assist this court by trying to find out whether you have issued any guidelines?
May I just submit, so far as guidelines are concerned.
That we have seen you affidavit.
Yes, but we stand corrected because guidelines have been framed. So,
Then you file your affidavit.
that affidavit, will have to be ignored. The ones we had filed earlier, because we are withdrawing it, your lordship may ignore that because while we were.
Okay, then now today what we'll do?
Yes.
We'll let you withdraw this affidavit.
Yes, my lord.
And allow you to file your fresh affidavit.
We are carrying the guidelines.
There's already a judicial order asking you to file
Very
an
well.
additional affidavit.
Very well, my lord.
Lordship, the fresh affidavit may be furnished to all the parties. Lordship.
You finish all the copies.
We will do that.
Mr.
M. Datta, my lord.
M. Datta, learned counsel, appearing on behalf of the petitioners, submits that it was only after filing the additional affidavit on 14th November 2024 that the petitioner had come to know that guidelines have been framed, by the central government under the provisions of subsection within bracket 3 of section 1A of the Forest Conservation within bracket Amendment Act 2023. Stop. He therefore prays for withdrawal of the additional affidavit dated 14th November 2024 and to permit the petitioner to file another additional affidavit within a period of 1 week.
1 week, my lord, then your lordship will permit me to place the guidelines also on record.
That's why I'm saying
Yeah.
permit you to file an additional
We'll
affidavit.
deal with the guidelines.
Permit the petitioner to file an additional affidavit placing the set guidelines. Stop. Praise the Lord. List after 1 week.
Let's, can your lordship give me a date, my lord, if it's okay, 16 December?
Okay, 16th.
I'm so grateful.
20 of daily leave.
Yeah, you can.
I've received my instruction, my lord, from the department. I've placed it, my lord.
Did you file it by way of affidavit? Oh, you file it by way of an affidavit so that the petitioner knows. You are Mr. R.C. Heard Mr. R.C. petition in person. Stop. Mr. D.K. Sharma, Leonard additional senior governor. Praise for weeks time.
2 weeks.
Praise for 2 weeks time. To place on record by way of an affidavit. To place on record the instructions received by him by way of an affidavit. Stop. Praise the Lord. List of-
21.
Now, see, in this case, I'm appearing for the department. We could not file our repeatedly, we required further time loss.
How much time do you want?
This 4 to 6 weeks loss, because here they have challenged rule 36(4) of the GST Act. And the issue is pending before different high courts.
Well, let's let it be 4 weeks. Otherwise, there is an interim
How much
protection.
time you want?
4 weeks.
Okay, heard. Mr.
H. Pitalam.
H. Betalan and council. Mr. Ezekiel and the standing council GST is allowed 4 weeks time to file affidavit. Stop. List after 4 weeks, interim order possible to continue till the next.
Grateful. Highly obliged.
22.
May it please your lordship. I'm appearing for the respondent number 1, 2, and 3. I require some time to file an affidavit, your lordship.
Okay, 120. How about respondent 8 and 9?
But 8 and 9, I think 8 appeared and 9, my lord, also appeared, my lord.
Lordship, I'm appearing for respondent number 8, Lordship.
Okay. And anybody for 9?
9 has also appeared.
I'm appearing for respondent number 9.
Okay.
Service is complete.
Heard Mr. S.K. Das, then at council for the appellants. Stop.
Well, there is some urgency in the matter.
Okay, Sina, you are appearing for 1?
Respondent number 1, 2, and 3, your lordship.
And Kataki?
I'm for 4, 5, 6, and 7, Lordship.
MS M. Kataki, Leonard. Standing council, animal husbandry. Department appears for respondents 4, 5, 6, and 7. Papa. Stop. MS N. Burman. M. Burman and council enters appearance on behalf of respondent number 8 and MS M. Oh, got it. Appears for the respond enters appearance on behalf of respondent number 9. Stop. Mr. R. Sina, Leonard Council. appearing for respondents 1, 2, and 3. How much time you require?
Hardly 7 to 10 days, your lordship.
1 week time? Is allowed 1 week time to file affidavit.
My lord, will kindly fix the matter next Monday, my lord. There is urgency because.
No, your lordship. Next Monday, it won't be possible for me, your lordship. Let it come out on 5th of December, your lordship.
Lord, the fund has come from central government. Whoever wins is not a factor, my lord. If the matter is delayed, the fund will go. So my humble prayer before the lordship will kindly take up next Monday or Tuesday, my lord, for disposal, my lord. Tuesday next.
28.
No, your lordship.
Why? You said you wanted 1 week time.
Your lordship,
Give me
26.
Apart from that, he has appeared for a caveator, my lord.
Your
1
lordship,
month
but-
back notice was issued.
Yes.
Your lordship, on 26, there are some other matters fixed in the division bench, which is sitting. That might get rolled over till 28.
We'll
also, and
see
some
to it,
matters.
my lord. We'll get.
Your
we'll
lordship,
take
let it come up
accommodation.
on 5th. Your lordship, let it come up on 5th.
My lord, I have got serious objection, my lord.
Okay, we'll have it on 28. If it is not possible, then you
Yes,
get the
my
date
lord.
fixed on that day.
My lord, 25th, my lord will take up. My lord will
No.
kindly take up 25th, my lord.
28.
My lord, let it be on hearing day on 27 at least, my lord.
Interim order passed earlier to continue.
28 is a
with the
hearing
next
date.
interim. You have an interim also.
Yes, my lord.
There is a status quo order.
Yeah.
Deeply obliged, your lordship.
23.
Deeply.
May I please, Your Lordship? I'm appearing on behalf of Mr. T.J. Mohan. In this case, affidavit is ready and we have submitted for vetting before the registry. So I pray for 3 weeks time to file our affidavit.
But MSN Begum, learned counsel for the appellant, petitioner. Stop. On request made on behalf of Mr. T.J. Mahanda, learned standing counsel, Guwahati High
Yes,
Court.
sir.
How much time?
3 weeks time.
2 weeks may be given,
2
it's
weeks,
already
okay.
taken time.
2 weeks time is allowed to file affidavit.
Lordship, if a
To
date
file
could be
counter
fixed.
affidavit. Today is 18. Okay. Second?
Much
Please,
obliged.
1 second.
Obliged.
24.
What is this? What is this?
21 and 24 are the same issue. In this case, also we could not file our affidavit, lordship.
21, I don't know whether it is because our is the issue of the rule 36.
Yes, in the 21 also 36 has been changed.
But on last occasion, it was the last date given, my lord. The last
Then, lordship,
opportunity given.
My friend argue, lordship. If he is such objection, lordship, like.
No, I don't have any objection to his timing. Now, 1 month time may not be given.
Yes, lordship,
Justify. Why?
lordship, because here rule 36 for has been changed and the matter is pending with different high courts. So department could not compile the issues, lordship. That's why we could not file affidavit. And my land patent agency, lordship, then let him complete his argument. I'll reply to that.
I'm not objecting to his filing the affidavit.
You file your affidavit, I'll give you a last,
That's why we prayed for
further last chance.
4 weeks time. Lord.
4 weeks will be too long, my lord. Next
I'll
week,
give you 3 weeks time.
3.
Well,
But
lordship,
Mr.
I'm Vinay Saraf.
V. Sharaf, the counsel. Mr. Ezekiel. The counsel. Appearing for the respondents is allowed another 3 weeks chance as a further last chance to file affidavit. List after 3 weeks.
My lord, can a fixed date be given, my lord, because I
List
come from
on
outside, my
one
lord.
week.
On 5th, my lord, if
Will not be 3 weeks. 11th December.
my lord, 12th, my lord, then kindly keep
Okay,
it.
12th December.
25.
Lordship, the state has to file an affidavit, lordship.
Who is the state?
Lordship, education department, lordship.
Chishti, Psychiatr, AG,
Elementary education.
Gogoi, SSA,
I think Gogo is for higher education, you know.
SSA.
SSC.
No, what is this? Where the standing councils? If they don't want to file affidavit, we list it for hearing.
Yes.
No, even the parties are not represented. Can you catch hold of one of them? I'll give you 1 minute. Sometime.
Yes, Lord.
26.
May I please your lordships? My lord, petitioner has raised an issue of pollution by the carbon factory. Although it's being stated by the respondent authorities that this is not a residential area, it's a industrial estate.
21/6/2024 order passed by this court.
Yes, lordship. We had, as per that, we had filed our RTI. Even the revenue department didn't know whether it's a residential area or industrial area. We have filed RTI to get the information from the revenue department. So whether that is a residential area or demarcated, this we have not bring into record, but we have filed the RTI, we got the information, lordship. There is no any notification and list available in this office regarding the area in the district of where is declared as a residential area or
You bring it by way of an affidavit.
Yes, lordship. And moreover, one small thing I would like to state, lordship, in the affidavit filed by respondent number 6, lordship.
No, we will go into that later on.
Yes,
First,
lord.
you'll have to satisfy this court in terms of the order of 21/6/2024.
And health hazard aspect, my lord, they themselves say that will bring it to court's notice.
No, that's why that thing is very clear in that short order.
Yes, lordship. May I
So you
submit, lordship?
satisfied,
With that, prior to that also, there are various news about the health hazard. And in fact, the petitioners also had visited the place, had talked to the respondents, talked to the residents of that locality, which is brought in a report, lordship, which is annexed along with the PIL petition.
See,
lordship.
that's why
Yes,
you
lordship.
bring us certified data on that issue.
Yes,
File an
lordship.
affidavit and then we'll consider it.
And lordship, even just before that,
no,
just
no.
one small thing I'd like to state before this honorable court, lordship. Consent to operate, which was issued on 24th of March 2022 by the respondent authorities to the respondent number 4 industry, lordship. But as per the inspection, which is also annexed lordship, they have made the survey subsequent, lordship. Consent to operate was issued on 24/3/22 and analysis of stock emission monitoring conduct, which prior to, as per the law, they have to, once that application is made, they have to visit the place and thereafter the consent to operate should be issued as per the law, lordship.
So the issue that this court, we are still harping on.
So, lordship, that whatever RTI replied.
File your affidavit.
Yes, lordship.
Bring on record the
Yes,
certified
lordship.
data of the residents of the area
Yes,
who are
lordship.
facing the health hazard. That's all.
And one more aspect, my lord. Now the petitioner themselves say
that based on RTI reply, they are not in a position to know whether it is an industrial or a residential. On what basis the averment was made in the writ petition that it is a residential area? Was it not a false statement made on oath?
May I submit lordship with that my senior friend what he had stated. Lordship, there is a LP school which was established. We brought in our rejoinder. As per our instruction, we know that that is a residential area. If not, it's a residential area. A primary school was set up, which we brought in in 1967, lordship.
We are not entering, you file your affidavit in
Yes,
terms of the
lordship.
order dated 21.
We have stated, because as per our knowledge, till date, we'll submit before this honorable court, it's a residential area.
How long, how much time do you want?
At least 4 weeks time, lordship.
MSD Ghosh, London Council for the petitioner, prays for 4 weeks time to file an affidavit in terms of the order dated 21/6/2024 passed by this court. Stop. Please, after 4 weeks.
27.
Lordship, in this case, the pleadings are completed. Lordship may admit the appeal and fix for hearing, Lordship.
It's not admitted.
No.
All parties are represented. Okay, heard the London Council for the parties. Writ appeal is admit. This the matter for hearing after?
After 1 week, Lordship.
1 week, your
2 weeks.
2 weeks.
in the
All right.
28.
Yeah, please, your lordship. Lordship, my senior is on legs in another court. Thank you.
Oh. Yes.
Lordship, my senior is on legs in another court.
Yes. And here the respondent has filed affidavit. I may be allowed to file reply to that one.
Reply. Okay. Otherwise.
Only 1 week time.
Otherwise, how are you affected?
No, affected means when 10% quota is gone to that ministerial staff, that one. Because now
Mr. B. Sinal, the counsel for the petitioner, is allowed how much time?
1 week time only.
1 week time to file reply to the affidavit filed by the respondent number 2. Please, after one.
All right.
29.
Yeah. May it please your lordship. My lord, in this case, we are assailing certain conditions incorporated in the NIT. Now, the fact of the matter is, my lord, because the interim orders were not granted, they have already gone ahead with the work. Now about 4.5 months gone out of 1 year. Na?
1 year.
So, my lord, effectively, even if I succeed, perhaps lordship will not interfere with the tender, I mean the award of the contract. Now, my lord, my submission is twofold. Either lordship decides the issue without interfering with the present work, or lordship keeps the issue open in future, my lord, so that in the next year, even if such conditions are incorporated, we may be given liberty. My lord, the matter is very simple, my lord. Please come to, I'll just draw your lordship's attention to 2-3 pages, and lordship can please come to page 77. It's a providing security personnel to my lord this establishment, that is Tezpur University. Now please come to page 77, my lord, and let's see what is the estimated cost of the work, 1.5 crore. As your lordship noticed it, my lord.
Yes.
Then my lord will kindly come to page number 79. To A. Providing male and female security guards, 154 approximately, for round the clock in 3 shifts per day, 8 hours per shift, security on campus at designated places. All that is to be provided is 154 security guards. Now, my lord will kindly come to page 86. Now, kindly see, my lord, how the technical bid would be evaluated. Now, how unequals are sought to be treated equally, my lord. Section D, technical bid evaluation. Similar experience in government, center, state department, autonomous, etc., maximum 20 marks. Executed single contract up to the value of 10 crore during the last 3 financial year, 10 point marks. Executed single contract value above 10 crore during the last 3 years, 20 marks. Now kindly see number of years in operation in service sector, up to 5 years, 2 marks, 5 years up to 10 years, 5 marks, 10 years up to 15 years, 7 marks, above 15 years, and that's not very relevant. Then annual turnover, kindly see, my lord, how it is disproportionate, how irrationality has crept in. Annual turnover of the company in year of the last 3 financial year, up to 100 crore, 5 marks, between 100 to 200 crore, 7 marks. Well, to do a work of 1.5 crore, why you need experience of 100 crore, 200 crore, my lord? Is it rational? Well, in spite of all the limitations of your lordships, in view of the recent trend of the judgment of the Supreme Court, but lordships will at least, if it suffers from the vice of irrationality, that is one of the, judicially recognized ground of interference, my lord. Then kindly see manpower on payroll, up to 5,000 numbers, 5 marks, above 5,000, 10 marks.
And it is 154.
And for all that is required is 154. Then, my lord, these are the criteria. Then please come to the note portion down below. The minimum technical score required to be eligible is 70. So unless I get 70 out of 100, then I'm not even technically eligible. Financial bid of the bidders getting minimum 70 or above technical score shall only be open. So unless, now 4, evaluation of financial bid shall be made solely on the basis of the service charge quoted by the bidder. The service charge quoted by the bidder shall be within the range of 3.8% to 3.85% to 7% on the basic wage component as per the minimum wages notified by Government of India from time to time. So, my lord, financial bid will be more or less static. Now, please come to 87. This is very important, my lord. 3. If more than one agencies have quoted the same service charge L1, bidders shall be selected on the basis of the maximum marks allotted to the bidder on technical evaluation bid at the sole discretion of the university. So end of the day, my lord, financial bid is irrelevant, my lord. It is the technical score which is decisive. Now, my lord, for a contract where a bidder is only supposed to provide 154%, how come they are, my lord, taking note of firms having 5,000 and above 5,000? So, my lord, my humble submission is that level playing field is not there, my lord. It's a case where unequals are sought to be treated as equal. So, my lord, this time they have already given. So, in future, they should not. That's why I made this initially twofold argument, my lord. Either your lordship decides without interfering with the work in question, or as your lordship may pleases, or lordship will keep the issue open. If tomorrow they come up with the similar, terms and conditions, then the issue should be kept open so that we can challenge it. At the end of the day, my lord, that proportionality is an area which has to be taken note of in administrative law, my lord. আমার যদি ইস্যুটা ওপেন করে রাখা দিতেও আমার আমাদের
Lordship, I'm for the university.
See, what the senior counsel is saying that now the work has there's no interim order. Now they have completed about 4 months has already gone. So now what instructions do you have on that?
Our conditions are reasonable, Lordship, but it is not violative of any condition of the terms and condition of any tender. Because Lordship, as pointed out by my learned senior, the turnout is up to 100 crores, up to 100 crores. We are not restricting anybody. Anybody can participate. And while the matter was pending before the learned single jail, they were given liberty to participate, but they didn't participate before the.
Just to respond to my learned friend Milord, at page 110, I have stated, going by the technical score yardstick, Milord, I will not score more than 32 marks, whereas the requirement is 70 marks. Because the credential which I possess vis-a-vis the Milord require 110. Para 4, the sub-para part, Milord. As per the technical bid evaluation, minimum technical score is 70 marks out of 100. And since the member of the petitioner association would only be able to score maximum 32 marks in the technical bid evaluation as such, by virtue of clause 1 and 2 of the TBE, they shall be automatically ousted from the tender process, and such participation would be a futile exercise with wastage of money and time. And my lord, if we go by this, nobody from Northeast can participate. End of the day, my lord, in medical admission cases, Supreme Court has even diluted Article 14 and 16, my lord. Why? Because having regard to the local interest. Or lordships can keep it on a hearing day also. Notice issue on any.
All have appeared.
All have appeared, so it can be fixed for hearing.
Okay.
That can be.
Heard Mr. K.N. Chowdhury, then a senior counsel assisted by Mr. P.N. And Dekal, then it's counsel for the appellant's staff. Also heard Mr. S.C.K.L., then a standing counsel, Tezpur University, and Mr.
Amit Grover for
Amit
respondent number 5.
Grover, learned counsel for the respondent number 5. For admit, list the matter for hearing. When?
My lord, first week of January, my lord.
Third?
Not third, my lord, next week.
Not next week, first week of January, I think, my lord, because.
Oh, you want it in January?
January. Okay, my lord, then my lord, lordship can have it on either 7th or 9th.
Of
January.
January?
Yes.
Okay. It's up to you. If
7th or 9th, my lord, subject to convenience of my
I
learned.
take permission to file the compilation of judgments in this.
See, this
compilation of judgment for
that is in regard to this thing. If a president is settled in regard to this, only the particular state should be given the preference for these reasons. And other party cannot be participated in.
Compilation of
that is not my prayer. I am just giving an example.
List on
We are governed by the same constitution. Don't worry.
9th of January, 2025.
We are governed by the same constitution.
30.
I don't want too much.
Lordship, the rejoinder has been sent for vetting just a week time, Lordship.
Which rejoinder?
We have to file a rejoinder to the affidavit filed by the respondent, Lord.
Okay. Mr. B. Chakravarti, CGC.
Lordship.
Press for 1 week time to file rejoinder to the affidavit filed by the
respondent, sole respondent.
By the sole respondent. List after 1 week.
32 hearing.
The last case.
This matter may be taken up on a hearing day, Lordship.
Okay.
Because this will consume 3-4 hours and all my other cases will get stuck, Lordship.
Okay.
Maybe
On
on
request
Thursday
made by
or
Mr.
tomorrow.
On request made by Mr. D. Cycle. Okay, General. When do you want?
Tomorrow also, Lordship. In fact, I am prepared with the case.
Lordship. Lordship, apart from 28th to 25th, Lordship, any day.
Then in the first week of December, Lordship.
Apart from 28th to 25th, your Lordship.
Third
3rd of December.
3rd of December.
Highly obliged, Lord.
One, order
Oh, we have more matters. So that other matter also is there, no?
May I please, Your Lordship?
Exhibit,
Lordship, kindly pass over the matter for adjournment after 1 week.
Okay, on request made on behalf of Mr. M. U. Mondal and the counsel for the petitioner, list after 1 week. What was this matter? What?
Give it this one.
25, admit.
Mr. Shishi was there, your Lordship. They challenged the rule, your Lordship.
Ah.
Yes.
So they have to file the affidavit.
Exactly, affidavit is very much required, your Lordship, otherwise.
Our Mazumdar is on license 27. He's on
Who?
our Mazumdar,
He's for?
Education Department.
So you want to file your affidavit or not?
A lot. I have no such.
Yes, Majumdar.
Amendment and the challenge rules.
State pool teachers, yes. I don't think we have filed a affidavit in some time.
Elementary, yes, okay.
What's this? Petitioner. Heard Mr. DJ Das on the concept. On request made by R. Majumdar, the Standing Council, School Education Department. How much time? 4 weeks. 4 weeks time is allowed to file a contract. List of.
Lordship, can a date may be fixed, your Lordship?
Yeah, the first time he's coming up with this.
Lordship,
Bless you.
Lordship, bless Lord.
Matter was already fixed last week, but not listed till today.
When was it fixed?
Last week, my lord.
Witnessing, we can have it. Will happen on 29th.
Obliged.
May I please, your Lordship, I would like to mention this matter for listing on 21st of November as the respondent communicated between them, which I would like to bring this before this honorable court by way of filing affidavit today.
What?
Listing a writ petition on 21st of November.
25th, Monday.
Understood.
May I please, your Lordship, I'm paying for listing of a pending writ petition in the admission column, my lord.
Okay. What?
Oblige, your Lordship.
Item 1 of daily list, admission, personal account.
Yes, Majumdar.
My lord, the present inspector of schools,
Yes.
Walpara, is here. Unfortunately, my lord, he is not the person who filed the affidavit in
Who's the person who filed the
It
affidavit?
was one Mr. Shadullah Khan. Perhaps when we sent the order to the department,
There was some confusion. The present IS who joined after him has appear before lordship. That would not perhaps suffice the intent of the order of the court, but the order, my lord, since it said that the IS should be present, it is the current person holding the charge.
Okay, we'll call
That
this.
that is one part of the matter, my lord. Otherwise, my lord, may I just go into the merit of the matter for
Yeah.
just to shorten the entire issue. We'll take up the issue of the personal affairs, why he did not state it. The process, my lord, which is under issue in this advertisement is a process which started in the year 2019. For whatever reasons, got stalled in the year 2020. And in the year 2022, during pendency of the writ petition, an act came into force, which required that particular post to be advertised under the direct recruitment post. There was no other option for the department. We cannot do it at the departmental level now. It has to go into the direct recruitment board, selection board. That is how this post came to be. Since it was a vacant post, we had to show the vacancy. That is how it came to be advertised in that particular advertisement, and the person was appointed. And thereafter, what I'm told, she is no longer in service because she chose to resign from the post. This writ petition, which seeks restoration of that earlier selection process, is not possible under the law as it stands today. Lordship may recall, my lord, there are several judgments of this honorable court.
No, that's one, Mr. Majumdar.
My lord.
During the course of the hearing, this court was considering only the affidavit filed by the respondent number 5.
True.
There is no whisper of any advertisement being issued and the post being filled up.
Yes.
Correct. So on that basis, when this court was hearing the matter, then it came to light when Mr. Saikia said, submitted, that no, there's an advertisement and post has been filled up.
It came as a. I find that there was another writ petition filed by the same writ petition, bringing on record that advertisement, but not bringing on that record that advertisement in this writ petition. In this writ petition, they have not got it on.
No, in this writ petition, the respondent who has posted in that post, that appointment has been challenged.
No,
that appointment has what
that
has happened,
petition,
the
which was
advertisement.
withdrawn by this honorable court on the resignation of the person who was appointed. This was 6554 of 2023 filed in 2023 after that advertisement, after the appointment. The petitioner also does not feel the necessity of bringing that particular advertisement on record in this. Had he brought it on record that there is an advertisement, everything gone, this also is infractious. He doesn't do that. Either of them. I'm not contesting your case on merits. What I am trying to say, my lord, is that advertisement would render this writ petition infractuous.
And that writ petition was withdrawn
by the petitioner who filed it. He said that there is a recruitment process, someone has been appointed, and they file a writ petition. Now, since that person resigned, it was withdrawn. This
in terms of that advertisement,
same post, because it is the same. Yes, in terms of the resignation, it was withdrawn.
No, there are two advertisements.
Yes, one which they had participated,
which the petitioner participated,
and challenged.
The other one which was advertised during the pendency of this writ petition.
Yes,
correct.
Yes.
So that writ petition was regarding to which advertisement?
Second advertisement.
Okay, which the petitioner did not participate.
Did not participate. Perhaps participated. We do not know. He did not participate. Someone else got selected. And
then you also equally responsible.
What had happened in this case, the advertisements we're supposed to be talking about, that advertisement was not issued specifically against this post. The name of that post has not been mentioned. That's why we have not challenged this advertisement.
Yes. This is a very erroneous statement in my humble submission.
Majumdar, I think you'll have to file a very
I will do that.
detailed
In this one, I bring a detailed affidavit and let him state on affidavit why he did not mention.
No, let him make his reply.
Because I have challenged this.
Then I'll release it from parted. There's no point keeping this matter parted.
Probably. And the personal appearance, Lordship may consider if Lordship desires that Shadullah Khan should be here, we'll have him here on the next. No difficulty.
Okay. Heard Mr. Ari Islam, learn counsel for the petitioner. Stop. The Inspector of Schools, GDC Golpara, is present in court in terms of the directions passed on 6/11/2024. Stop. However, comma, however, comma, the affidavit on behalf of the respondent number 5 filed on 23/5/2023 was sworn by one Mr. Shahidullah Khan, comma, son of late Batul Khan, who was then the inspector of schools in GDC Kolpara, Assam, and not the present inspector of schools GTC Golpara. Stop. In that view of the matter, comma, this court directs that the said Sri Shahidullah Khan, who was the then inspector of schools GDC Golpara, Assam, should appear in person before this court. When do you want? When can you file your affidavit? That time I want to file. I want to have it.
Worship will have it on the second week of November, December.
On
12th, let it be a hearing day, my lord.
On 12th December. Huh? Stop. Para. Considering the sequence of events that has taken place, comma, after that has taken place after the filing of the present writ petition, comma, Mr. R. Majumdar, Learned Standing Counsel,
Department of School Education.
Department of School Education is directed to file a consolidated affidavit in opposition within 2 weeks. Stop. List this matter on 12th December.
This personal appearance will be
the personal appearance of the present inspector of schools GDC Kolpara is dispensed with for the time being.
God bless.
2, 3, and 4 orders.
What is this order? IA is for what?
I may please your lordship, is IA for correction of typographical mistake in the order dated 6/11/2024.
6 1 minute. Page?
Page 44, page 44, para 2. The said matter was listed for motion on 6/11/2024, on which date notice of motion was issued, returnable by 4 weeks, and was ordered to be listed.
No. What is the typographical mistake?
50, page 50, my lord.
Huh.
The last line. List the matter after 4 weeks, along with WPC number 5067/2020. It should be 2024.
Okay. Heard, Mr.
SK Das.
SK
Das.
Learned Counsel for the petition, for the applicant in the IA. Huh? By this application, the applicant is praying for correction of a typographical mistake, error that has crept into the order dated 6/11/2024, passed in WBC 5616/2024. Stop. Para. It is the submission of the learned counsel for the applicant that while this court issued notice in WBC number 5616/2024 on 6/11/2024, this court had directed that the present writ petition, that the said writ petition should be listed after 4 weeks, along with WBC number 5067/2020. Stop. In fact, comma, the correct writ petition is WBC number 5067/2024. Stop. Para. Considering the submission made by the learned counsel for the applicant, comma, This court is of the considered opinion that a typographical error has crept into the order dated 6/11/2024, passed in WC number 5616 of 2024. Accordingly, the order dated 6/11/2024, passed in WC number 5616 of 2024, is corrected by directing that the writ petition number 5616 of 2024 be listed after 4 weeks, along with WBC number 5067 of 2024. Well, I is accordingly disposed of. Now let's pass the order in the main writ petition. Yes.